Welcome to the Estates Made Simple podcast with Jenna Carvello and Gordon Vanderleek. We are on a mission to simplify the world of estate administration, helping executors gain the knowledge required to manage an estate. Please note, the following is for informational purposes only and is not to be considered legal, tax, or financial advice. We recommend you seek individualized advice for your unique situation with qualified professionals.
Hi, Gord. Nice to see you today. I'm looking forward to our conversation.
Yeah, it's great to be podcasting again. It's always a bright part on the calendar when I see that we have this time together and we get to chat about interesting estate administration issues. So what do you have for us today?
Well, today, let me tell you, Gord, we have a very unique topic. I think, in the past, our episodes have been focused on if an individual passes away with a will. But we really want to talk about today is what happens if an individual passes away without a will. What does the family do, and who actually has control over the deceased assets and final arrangements? So just as a bit of a background, when you pass away, you can pass away testate, which means you pass away with a will and with a plan, or intestate, which means without a will. And if you pass away without a will, the province has set guidelines of how your estate should be distributed. So you sort of leave it up to the government's hands as so to speak. And I know that's the common theme that many people think, the provincial legislation gets to decide where your assets are divided. And of course, they go through a line of, who gets first right to receive it, as well as who gets first right to apply to have control over the division of your assets. So, if you're sitting here listening to this podcast, you just lost a loved one, you don't know where to start because they passed away without a will, this hopefully will provide some information for you. And of course, you want to get some advice for your specific situation. So Gord, if you are advising an individual who lost a loved one who passed away without a will, what would you say and where would you tell them to start?
Yeah. So with that, there's really, as you've identified, two issues. Who's going to make the application to be administrator, right? We talk about in the past, we've talked about a grant to probate. That's if a will exists. But as you say, if somebody dies intestate or without a will, it's an application for a grant of administration. It looks a fairly similar process and to probate, except there's no will to submit, which lays out these issues, right? How are assets divided and who's in charge, being the executor. So if somebody dies without a will, as you've indicated, the government's laid out a set of default rules. Sometimes we refer to those as the intestacy rules. So we start first with how do things get divided up, and that's contained in the Wills and Succession Act. So I guess if people are really bored, they can go and read Part 3 of the Wills and Succession Act, and that says, hey, if somebody dies without a will, then these are the rules that apply. So as you say, there's always a set of rules. There's never a situation where there is no rules. So we have a scheme of distribution that they're deemed to have accepted because that's what the law says if somebody passes away without a will in Alberta. So the rules are, first we basically have to do a family tree exercise, right, to determine where funds go. And so assuming there's a surviving spouse or partner being an adult interdependent partner. So there's a test with regard to that I think we've spoken of in prior podcasts, but so a spousal equivalent, if you will. So when I say spouse, I also mean somebody who's not married, but has the status of an adult interdependent partner. The rules say that everything would go to that spouse if there are no children, or if children are surviving where the deceased person was married and those are their children. So it's not in other words, not a blended family situation. And then everything would go to the surviving spouse. Now there could be a scenario where there might be more than one spouse. I have seen that, right? Where somebody is married. There's a provision in section 63 of the Wills and Succession Act to say that if somebody has been living separate and apart for more than 2 years, then they're deemed to have predeceased, right? So then they're no longer eligible to receive. But let's say they separated in the 2 years, but then they also had a relationship, right, with somebody, or then got, there's a fact situation where there's two spouses, then in that situation there would be a split. If there are children of the relationship, then if there's not a surviving spouse, then it would go to the children. Part of the problem that we talked about before is that, of course, if the children are minors, then the office of the public trustee is involved in managing that and managing those funds until the child turns 18. So hopefully they've done their planning if there's kids involved, and that's often a reason people go get their will in place, because they go, oh, we need a trust provision for the kids. We don't want the government managing their inheritance. It's not that the government gets the money, but the government would be involved in managing it if there's no plan in place.
And then the kids would get the inheritance when they turn 18, which, I wasn't as mature as I am now in my old age, Gord. Receiving that bulk of money at 18 would be much different than receiving it later in life.
Yeah, and for those reasons, that's usually a high motivating factor for people to have that proper testamentary trust in place to manage money going to, a young child. Legally, they're 18, they're entitled to it, right? That's, unless the court orders otherwise, they would receive it, and that's usually not a good result, right? For the reasons you've indicated, that 18-year-olds are typically not hanging around financial planners, and they're thinking about other things at that stage in life, and putting a bunch of money into their pockets can lead to it being spent frivolously and or poorly invested, or they can be taken advantage of, right? So, but effectively the distribution will be to nearest next of kin. So if a child has predeceased and they have children, so there's grandchildren, then their share would go to the grandchildren. And if there's no spouse, no kids, no grandkids, then it would go up the family tree. So then you look to parents. If the parents aren't alive, then it would go to siblings. If a sibling is predeceased, it would go to their children, which would be like nieces and nephews to the deceased person, or could eventually spread even beyond that, right? There is a whole chart in place, and the rules indicate you can go up to 4 generations. So it gets a little bit complicated, but general theme would be it's going to go to nearest next of kin. So it will go in for a spouse, to spouse, then children, then grandchildren. So the problem is there may be a lack of particular trust provisions, but another problem is there's certainly a good number of families that are blended families, right? Where there may be children from a prior relationship. So if the deceased person passed away with children from a prior relationship, they're going to share in the estate, right? Not everything will go to the surviving spouse. So there are rules in place that if it, in a situation, it would go half up to 50% of the value of the estate, or the prescribed amount, which is currently 150,000, would go to the surviving spouse, and the other half would then go to the children, be split with the children. So especially the other takeaway, if you have young children, you need a properly drafted trust provision for those children. If you have a blended family, you definitely need a will, because it may be the wrong result in terms of how the money gets spread out, and is a spouse going to be properly provided for? So that's where custom planning is paramount for that. So it's basically, a rule of thumb is nearest next of kin, other than in a blended family situation where there's some different rules apply. And the other aspect that we want to talk about is who has the priority to apply. And then we move to a different piece of legislation called the Estate Administration Act, and it has a provision that indicates who has priority to apply. And that's, if people want to look it up, Section 13 of the Estate Administration Act says that if a person passes away without a will, here's the priority. And again, it sort of follows a similar, pecking order, if you will. It's a surviving spouse or partner would be first, then adult children, then grandchildren, and then the descendants, or it goes up to parents, brothers and sisters, and the like. So you could, depending on the family tree drawing, if you mapped it all out to say, what does the family tree look like, it could get quite complicated to figure out who's going to apply. And everybody within that class has an equal priority to apply. Let me give you an example. We had a few years ago where mom passed away and there was no will, and 6 kids. So the one child came forward and said, well, she was actually under the power of attorney, but there wasn't a will. So it was a bit of an odd situation that usually you see all the documents in place or none of the documents. But so managing pursuant to a power of attorney, which of course stopped at the date of death. And then she goes, well, I'll carry on and continue to be the executor. The problem in this case is that the family was somewhat divided, and there was a camp of 3 on one side and a camp of 3 on the other that didn't like each other. And so she had the unenviable task of going to the other camp of siblings, if you will, that were not enamored with her and get their consent that she could apply to be the administrator of the estate. In the end, she was able to get those renunciations. But while it seems simple to say, oh, there's a clear order of priority, the problem is, well, what if all the kids don't agree? And right away, you can't, the first thing you have to do is run around and get everybody to agree. Well, maybe that's fine, but what if somebody's living in Australia, or you need original documents and witness, the witness has to swear an affidavit, and it becomes, there's a level of complication that can slow down and delay the administration of the estate. So this is where it's appropriate to get legal advice to say, do I have priority, and what do I need to get the consent of everybody who has an equal priority with regard to that. So that's where just having a simple will makes it so much easier to be able to just move quickly into saying, well, I'm the nominated person, right? And then they can make that application and start the administration of the estate that much quicker. So there is an order of priority, and can get a bit complicated depending on the family situation. So legal advice is encouraged, I think, to figure out, do you have priority and what happens, which of course, if the will is there, you don't even have to ask the question. So it raises the planning opportunity to say, get your will in place. That's a great benefit, that you eliminate all of that. Like in my example, mom could have picked that one daughter out of the 6, going, well, that's the logical choice. Had she just done that, which probably she would have, had she put her mind to it and put the legal document in place, that estate would have started out without conflict in the beginning. Right? I mean, thankfully, it did get resolved, but I've been in situations where I've had to go forward to court to be able to, get a court order because the people can't agree, right? So it's now that starts that level of uncertainty at the front end of the administration of the estate, which is not desirable. So yeah, in addition to gathering all the information about the assets and liabilities to complete that application to the courts in terms of the inventory and going through that process, then just have to figure out who has priority and does everybody agree, and then figure out who are the beneficiaries of the estate. And that may also, the other issue that sometimes comes up is, well, if it goes to certain people, well, can you find those people? It doesn't happen a lot, but it does happen that you go, well, yeah, we have a brother who's been estranged from the family. He's living off grid. We have no idea where he is. You have a missing person, right? You don't even know where that person is. So now you've got to waive, get a court order to waive their requirement to consent to the appointment because we can't find the person, right? Again, could all have been avoided with a proper will. But yeah, there are some rules in place, and they apply if somebody has not done their planning. So that would be the first thing to determine what's your position in that, who has priority, and get some advice on that at the front end.
Well, and I think one negative consequence of not having a will is because there's no one appointed right at the start, the estate is sort of in limbo. And immediate decisions can't be made. So if there's stocks that need to be sold, no financial institution will take a request from a family member without the proper appointment. So that could negatively impact the value of the estate. Assets might not be insured or might not be secured well enough. So all these sorts of things could be mitigated if there was an executor who had full power immediately after death. And I think, even when we go to bill payments, maybe the bank won't allow certain bill payments to go through without an executor making those instructions. So we often think about, about dying without a will is harmful to our estate distribution, but also harmful to the ultimate value of our estate.
Yeah, no, those are good points. And there's certainly risk that what if you assume you're the one that's going to be the administrator? And of course, my siblings will agree, but they don't, right? Now we're in a situation where you may have started to make decisions or begun to make certain promises to people or attempt to do certain things, incurring some costs. You're proceeding to hire a realtor and all that. And what if it turns out you don't have the authority, right? So in a prior episode, we did talk about be careful how far you go to intermeddle in an estate, or there might be that it might be hard to get out and it may require a court order. So your point's well taken, is that there's that cautionary first period while you're trying to sort out things, and that's the period in which decisions cannot be made.
Right.
Yeah. So that leads to definitely some problems, especially if there's decisions have to be made on a timely basis, for sure.
Well, I hope our listeners got some value out of today with respect to the estate administration. If you're listening as well and you do not have a will, this is a little hint to get your will in place, as well as your enduring power of attorney and personal directive documents. Spend a few $1,000, get it done. You can save a lot of costs worse in the long run if you pass away without a will. Well, thank you, Gordon, for the chat today. Please feel free for our listeners to subscribe to future episodes. We're on Apple and Spotify, as well as YouTube. You can see our beautiful smiling faces every episode. Look forward to chatting with you next time, Gordon.
Thanks, Jenna.